The minutes of a standard committee meeting are usually a record of what was said, but in the governance of modern residential societies, these internal documents are increasingly being used to perform a much more significant function. Local managing committees, originally formed to oversee shared facilities, are now using meeting summaries to exercise powers typically reserved for sovereign legislatures. We can see the mechanics of this shift in the April 18, 2026 meeting minutes of the Vasant Vihar Army Residents Welfare Association in Bengaluru. These records show the association attempting to regulate private property rights, dictate tenancy agreements, and restrict access to essential services based on the outcome of a single committee discussion. The committee relies on a specific administrative pipeline. A contested issue is recorded as an agenda point, and by the end of the meeting, that same point is recorded as a binding decision. This illustrates the mechanism. A member's objection enters the process, passes through a closed committee decision, and emerges as a quasi-regulatory rule. Once recorded, these minutes circulate as binding law, creating a pattern where administrative record-keeping replaces formal legislative procedure. Treating administrative minutes as enforceable law bypasses statutory checks and allows a committee to invent policies without legal debate, creating a significant rule of law deficit for the residents. A registered mutual benefit society is not a sovereign body. It possesses no inherent power to govern its members' private property or personal arrangements outside of explicitly delegated registered authority. When a committee substitutes meeting minutes for statutory authority, it commits an ultra vires act, an action taken entirely beyond legal jurisdiction. To understand why these actions fail legal scrutiny, we have to map the objective framework that limits the power of any registered society. This hierarchy begins with a foundation of state laws and constitutional protections. Built on top are registered bylaws and valid general body resolutions. Finally, at the very top, the managing committee is the smallest layer, completely subordinate to the laws and bylaws beneath it. The committee's sole legal function is to administer existing law and properly registered bylaws. It does not have the authority to create new private legislation from the top down. If an association wants to change the rules, it must follow rigorous statutory requirements. Under the Karnataka Societies Registration Act, an ordinary monthly meeting cannot alter a bylaw. A legal amendment requires a properly convened special general meeting, 21 days of written notice, and a supermajority resolution passed by at least 3 times the number of votes against it. Even after that vote, the amendment does not become active until it is formally filed and approved by the government registrar. This brings us to a pervasive misconception, the majority myth. Committees often assume a simple general body vote grants them unlimited power over individual members. A democratic vote governs community management. It cannot be used as private legislation to curtail individual ownership rights that are already protected by state law. We can apply this legal baseline to the first stress test from the RWA case, the committee's blanket prohibition on multiple tenancy and floor-wise leasing. To justify this ban, the committee cited original sale deed undertakings and a township master plan specified for 424 dwelling units. We can test that decision using this lawful decision matrix. A valid regulatory action must satisfy every criterion. The tenancy ban fails the first 2 tests. The committee cites no registered bylaw and no statutory provision granting power to prohibit floor-wise leasing.
Relying on municipal layout approvals to block a lease is a misinterpretation of civic planning documents. Infrastructure blueprints dictate physical building safety and zoning density. They do not grant a private association the right to bar a residential rental agreement. The right to lease private property is secured by Article 300A of the Constitution and the Transfer of Property Act. The committee also offered no proof that the units had been physically subdivided in violation of building codes, or that the tenants presented a verified safety nuisance. Blanket bans also ignore the socioeconomic necessity for aging residents to utilize partial unit rental income to support their own properties. Without proof of illegal structural modification or a verified breach of municipal norms, banning floor-wise leases is disproportionate, rendering the decision ultra vires. The second stress test reveals a deeper jurisdictional overstep, the unauthorized enforcement of fines and the use of outright coercion. The April minutes record the committee levying a penalty of 1,500 rupees per month on vehicles parked under loosely defined permanent conditions. This assumes a power the association does not possess. A private committee cannot monetize internal community roads that the society does not legally own. The minutes also reveal a structural flaw, authorizing a single representative to act simultaneously as the investigator, the judge, and the enforcement authority. This unchecked authority escalated to the punitive stoppage of garbage collection to a specific dwelling unit. Suspending essential sanitation services as a response to an alleged parking violation crosses a clear legal boundary. Using municipal utility services as leverage to enforce internal rules violates the basic principles of natural justice and proportionate governance. These coercive actions were coupled with an administrative tactic that silences dissent, dispatching decisions exclusively via do-not-reply email addresses. Routing legally binding penalties into a one-way communication channel only proves that a document was sent. It does not establish consent from the community. Disabling replies creates a governance defect that removes a member's right to object, to seek factual correction, or to demand due process. Correcting these ultra-virus acts requires specific administrative remedies that bring the society back into compliance with statutory law. The immediate remedy is a formal freeze on the enforcement of all disputed quasi-regulatory decisions. This freeze must cover tenant surcharges, unlawful tenancy bans, arbitrary parking penalties, and any disruptions to essential services. To lift this freeze, the committee must meet a strict legal condition. They must present the exact registered bylaw that grants them the authority to act. Moving forward, the association must institute a two-way channel for member objections. This must connect to a formal objection register, a mandatory check against state statutory authority, and an objective fact-finding mechanism. Before any regulatory action is enforced, the committee must issue a speaking order. This document explicitly states the legal source of power, the facts discovered, and the logical reasoning behind the decision. AGM resolutions must also be recalibrated. They are policy directions that must be tested for legal proportionality before they can be implemented as rules. Finally, the society must maintain a consolidated set of bylaws that explicitly align with state property law and constitutional protections. Adhering to these statutory limits ensures that community governance remains an administrative function, protecting both the association's residents and its office bearers from avoidable legal exposure.